So welcome. This is pre-trial conference for the case of public prosecutor against Genesis Mitchell David Reddy. So my name is Izzat Nizati, and together with me is Puan Ilin, representing the Deputy Public Prosecutor Jin Xiao Chong Hui.
Good morning, Puan DPP. I am Tunku Anis, the Defence Counsel for the accused, Mr. Genesis Mitchell. Together with me here is my learned co-counsel, Siti Nur Rashida. And we are replacing the authorities from Legal Aid Foundation, which are Russell Lim, Brandon Ting, and also Zoe Chen.
Okay, just to confirm, is the accused the one sitting beside you?
Yes, I'm the accused, Genesis Mitchell David Reddy.
Today is the 13th of November 2025, the date that we have agreed to conduct our pre-trial conference. Is that correct?
Yes, Puan DPP, that is our agenda for today.
Alright, since everyone is present today, so let us start the session. As provided in Section 172, Capital A of the Criminal Procedure Code, today is our pre-trial conference. So these sessions is aimed to discuss matters that can facilitate the speedy disposal of the case without compromising justice and ensure a smooth process during the trial, as all the relevant facts are disclosed before the trial. Puan, are you clear?
Yes, we are very clear with the briefing, and I have also briefed my client on this matter, and I am sure that he is well aware of the procedure.
Yeah, Puan DPP, I'm fully aware of this pre-trial conference procedures on.
Okay, that's good. We hope that by the end of this session, we will be able to agree on certain terms that we may discuss as mentioned in Section 172 Capital A, Subsection 4 of the Criminal Procedure Code before the commencement of the trial. So today, we will discuss several important points as part of the preparation for the trial. So firstly, we will identify the facts and legal issues in this case. Secondly, we will narrow down the issues in contention. And thirdly, we will clarify the position and stand taken by both parties. In addition to that, we will also ensure compliance with Section 51 Capital A of the Criminal Procedure Code, where we will deliver to you documents that are related to the trial and also other related matters. And then we will discuss the nature of the case for both the prosecution and also the defense. And then we will discuss plea bargaining. And then we will sort out matters that both of us may agree on, which will expedite the disposal of the case. And lastly, at the end of our pre-trial conference, we will prepare the pre-trial agreement that shall be signed by all the parties. So are we all clear on this? Does the Defence Counsel have anything to ask?
No questions as of now, as we are clear on the pre-trial conference procedure as explained before.
Okay, so let me start our pre-trial conference. So I will read the charge sheet first. So based on the charge sheet, the charge is read as that you, on the 26th of April 2025, at approximately 4:30 a.m. at Jalan Stephen Yong, 93250, in the district of Kuching, in the state of Sarawak, had committed the offence of murder by causing the death of one Muhammad Zaki bin Idrus, National Registration Identification Card number 9107-12-2163 by shooting the victim, who was inside a white car of Perodua Myvi type bearing registration number QAD 3344X, causing his death, and thereby you have committed an offence under Section 300 of the Penal Code, which is punishable under Section 302 of the same Act. So the punishment for the offence is, if you found guilty, the accused shall be punished with death or imprisonment for a term of not less than 30 years and not more than 40 years, and if not sentenced to death, shall also be punished with whipping of not less than 12 strokes.
No, Puan, I did not murder anyone. I'm a police officer. How could I do that such nasty thing?
Calm down, Mr. Genesis. This is part of the procedure today, and Puan DPP was just reading the charge and allegations against you.
Okay, Puan, but I did not kill anyone.
Alright, such is the charge against you. Now, we proceed with the facts of the case. So we will read out the facts that we have received based on the investigation paper that the police has handed it to us. The defense can choose to agree or disagree with any part of the facts. So if defense disagree with the stated fact, kindly inform us accordingly, and we will take note of any objections.
Okay, understood.
So according to the investigation report by the investigation officer, the accused is a 30-year-old who was a lance corporal serving in the traffic division at Bukit Aman and was temporarily assigned to duty under the Sarawak contingent. And the victim, identified as Muhammad Zaki bin Idrus, is a 34-year-old civilian. So on the 26th of April 2025, on a Saturday at approximately 4:30 a.m., the accused was carrying out patrol duties along a quiet stretch of Jalan Stephen Yong in Kuching, Sarawak as part of a routine early morning enforcement operation. And during the patrol, the accused noticed a white Pro 2 Myvi bearing registration number QAD3344X parked in an awkward position by the roadside with its engine still running but the headlights switched off. So finding the situation suspicious, the accused stopped his patrol motorcycle and proceeded to inspect the vehicle. Is this correct?
Yeah, that's absolutely correct.
So in this report, Mr. Genesis, the accused found that there were 3 male individuals inside the car, and the accused then introduced himself and requested identification from them, but they refused to comply. So the victim, who was the driver, looked nervous and was seen to reaching towards the center console, which the accused interpreted as evasive and potentially threatening. To this fact, the accused thinks that the driver might be trying to take out the weapon or hide something. So due to this, the accused drew his service pistol and issued a verbal warning for the occupant of the car to remain still and show their hands. So do you agree with the facts, Mr. Genesis?
Yes, but my suspicion was justified. It was so early in the morning. What could they doing there at the secluded area? And why did they refuse to provide the identification?
Mr. Genesis, we are here trying to clarify the facts first. So if you could please remain calm. So the accused here claims that the victim ignored repeated warnings and also made another abrupt movement. So believing that there was an imminent threat, the accused discharged a single shot through an open window, which had fatally wounded the victim in his head. So the other 2 occupants in the car, namely Ahmad Faizal and also Daniel Lim, fled the scene and reported the incident at Batu Kawa Police Station to 1 Corporal Azman bin Saleh, Police ID CPL/BTK-072941 at around 5:30 in the morning. So in their statement, they alleged that their friend had been shot without any apparent reason.
No, I shot because he was so threatening at that time. I only intended to fire a warning shot and not to hit anyone. He refused to comply with my order, with the procedure, and he was very suspicious at that time. That was the only reason why I opened fire. You can't expect me to risk my life like that. It was 3 of them at 4:30 a.m. in the secluded area, and also they also shouting, "Kau tunggu lo." So anyone would be scared of that.
Mr. Genesis, I would request you to please be calm. Puan Dina and Puan Izian, we disagree with the fact that the accused had shot the victim without any reason. The accused had intended only to fire a warning shot as he was feeling threatened by the victim and his friends of the non-compliances in failing to provide the identification card. So the act of shooting the victim's head, which led to cause his death, as the accused never intended for the bullet to hit the victim's head, he fired the shot only again to give a warning to the occupants of the car and not to hurt anyone or the victim.
So I take note of that as disputed fact. So shall I resume? So the accused was arrested later that day with his service weapon, a Walter P99 with 10 bullets, which was seized. Forensic analysis later confirmed that the bullet recovered from the crime scene matched his firearm. Inside the Pro 2 Myvi, there were no weapons, narcotic or illegal items discovered. So do you agree with the facts?
Yes, I agree. However, I did not kill anyone. I'm a police officer. How I could shooting anyone without any valid reason?
We have taken note of that, Mr. Genesis. This is all on the facts. Defense counsel, are there any facts that you would like to add?
Yes, Puan. So far, actually we don't have any fact to add, but we will like to repeat a certain facts earlier. So the first is that our client denied that he had fired the shot with the intention to cause death to the victim or injury to the victim. And also our client only intended to warn the occupants of the car as he felt threatened by the situation, and because the area was secluded area and he was only one man against the three suspicious men. And lastly, I want to repeat that our client also stated that the act of shooting the head was purely an accident because he never intended for the bullet to hit the victim's head and did not expect that it would cause a death to the victim.
Okay, we have taken note of the disputed facts as raised by the learned counsel. Other than that, are the remaining facts that we have raised just now agreed upon by our client?
Yes, my client agrees to the rest of the facts.
So based on the fact of the case, there are two legal issues to be determined here. So the main legal issue is whether the accused is guilty of murder under section 302 of Penal Code for causing the death of the victim. Next, the second issue is whether the accused fulfill the element of actus reus and mens rea under section 300 of Penal Code for causing the death of the victim. Under the first mentioned issue, we would like to propose the following issue. So the first one, whether the accused act of shooting the victim had caused death to the victim. And the second one, whether the accused had the intention to cause death to the victim when he shot the victim in the head, and whether the accused can rest the defense of provocation and mistake.
I'm tired of this accusation. I did not kill anyone.
Mr. Genesis, there are only legal issues or question of law that will be discussed during the trial later. You can calm down and depend on us to ensure your justice.
Yes, fine, but please make this woman understand I did not kill anyone. I'm a good man.
Okay. Puan DPP, we understood that there are two issues identified by the prosecution on both the conduct and the intention of my client in this case. So to determine whether it constitutes the offence of murder or not, we agree to the issues as mentioned.
Alright, can we take note of that? So now that the factual and legal issue has been determined, we will proceed with our second agenda, which is to narrow down the issue of contentions.
Sure, I think we can continue with that.
Okay, so we will outline the issues of mens rea and actus reus, which will be addressed in the trial
But
later.
Puan, before that, please allow me to explain this to my client first.
Okay, sure.
Okay, so Mr. Genesis, to ease your understanding, I will explain to you the meanings of mens rea and actus rea. So first, actus reus is the action or conduct that constitute the elements of the crime, and the other element is mens rea. So mens rea is basically the mental element, which is the intention to commit the crime. So I think in a layman term, it's about the the actus rea is what you did physically, and also mens rea is what is in your mind when you committed the crime. Do you understand?
Yeah, you mean that actus reus is the physical action, right? And the mens rea is what I intended. Okay, fine, understand it.
Okay, so just to reconfirm again, I hope you can understand what have been explained by the learned co-counsel. But these two elements is very important for you to understand, Mr. Genesis. This is because both of these elements must be fulfilled to prove a person have committed murder in the first place. So this is a further discussion on the legal issues that the VPs have mentioned. So I hope again it is clear with you.
Sure, it's very crystal clear.
Okay, so your client here is charged under section 302 of the Penal Code for causing death to the victim, and the elements of murder are under section 300 of the Penal Code. Therefore, the prosecution, we are required to prove the elements of actus reus and also mens rea in this case. So for the element of actus reus, which is the act of causing death, we have evidence that your client has caused the victim's death by shooting him in the head. And for mens rea, we need to prove any one of the elements mentioned under section 300, subsection A to subsection D. And for this matter, we have proved that your client has the mens rea as specified under paragraphs A, B, C, and D. So these are the prosecution's contention.
Okay, but the defense disagree with the DPP's contention. As mentioned earlier, we disagree with your statement that our client fulfill the elements of mens rea and accidents.
Yes, and furthermore, the elements of mens rea are disputed as our client has no intention to cause death as per mentioned in the para A, B, C or D. So firstly, my client has no intention to cause death. He also did not know that whatever he did, the bodily injury that he caused will likely to cause death. He also does not have a knowledge that it would cause bodily injury which is sufficient in the ordinary course or of the nature to cause death. And lastly, he have zero knowledge of that such an act is so imminently dangerous that in all probability it will cause death to the victim. So that is our contention for this case.
So we take note of that as disputed facts. Now, we may proceed to clarify each part position here. The prosecution submit that this is prima facie case as the accused action clearly demonstrates that he caused the death of the victim by shooting him in the head. This is also supported by a statement given by 5 witnesses, which is I will is it in this file one?
Let me try to check first.
So there are 5 witnesses in this case. So the first one is Ahmad Faizal bin Osman. The second one is Daniel Lin Weija. And the third one, Dr. Alisa Esther from Hospital Umum Sarawak. And fourth one, Muhammad Iskandar bin Samad. The last one is Inspector Norainin binti Abdullah, the investigation officer that handled this case. So there are 2 eyewitnesses who were in the same car as the victim, and they saw what the accused shooting the victim in the head.
1 DPP. I have to disagree that this case is a prima facie case, as there is still a reasonable doubt with regards to the mens rea of the accused during the crime. The accused did not intend to kill him, but only intended to fire a warning shot. Again, I stress on this. So based on our discussion, even if the prosecution had shown that the accused had shot the victims and caused his death, there are still elements of mens rea under section 300 of the Penal Code that the prosecution has yet to prove.
Yes, I think it must be proven that the accused had the intention to cause death in the first place. And furthermore, for the accused to be found guilty of the offence per charge, the prosecution must prove it beyond reasonable doubt. Since the elements of mens rea here are yet to be fulfilled, this case could not be a prima facie case.
I did not intend to kill anyone. I was feeling threatened at the time. It's so 3 against 1. So I only intended to fire a warning shot as they did not comply to my orders. Please, I really did not kill anyone.
Okay, accused, if the defense contended so, we suggest that the defense to call witnesses to prove otherwise.
Alright, we will take note of that.
Okay, now we will continue our discussion on the documents that are related to the case. In complying with section 51 capital A of the Criminal Procedure Code, which require the prosecution to deliver some document to the accused, we bring here the document for your perusal. So these documents are important as they clearly related your client to the crime he is charged with.
Thank you, Puan DPP. So is this everything that the prosecution had for the trial?
Yes, these are the relevant ones as of now.
Okay, let us see. First, I have given to you the charge sheet that contain the charge against the accused. This is the charge sheet.
Okay.
Okay. I see. So for now, I think we would go through this document first later. Puan DPP.
And this is the prosecution list.
Okay, Puan DPP, can I show the charge sheet to Mr. Genesis first?
Yes, you sure.
Okay, so Mr. Genesis. Okay, so basically that is the charge sheet. You can see. So here, it stated that it is charged against you that you have committed murder, punishable under Section 3 or 2 of the Penal Code. If you are found guilty, you are liable to the punishments of the death penalty.
Stop saying that. I did not kill anyone. Okay, I don't murder anyone.
Okay, it's okay, Mr. Genesis. I will take this first from you, and I hope you can still please remain calm. And because this document only contains the allegations and the charge against you. This is the procedures that we have to go through in order to proceed with the next move.
So next is the prosecution list of witnesses that I have been mentioned just now. So I would like to ask, how many witnesses did the defense intend to call?
Okay, for now, the defense is planning to call 3 witnesses. Firstly, the accused himself, and we have the 2 other witnesses who are, I believe, named Ahmad Faisal and also Daniel Lim, who were in the car with the accused, who were in the car with the victim at that time. And for now, we are still finalizing the witness list.
Sorry, Puan. Do you have the statement from your witness?
Yes, it's included here. Do you wish to examine them?
Okay, yes, I do.
Alright, I will give to you later.
Okay, the next document is the autopsy report by one Dr. Alisa Esther, a pathologist from Hospital Umum Kuching, Sarawak.
I'm sorry, is this the government hospital?
Yes, Puan.
So next, the photo of the client.
Okay, alright. Let's see. Alright, Mr. Genesis, do you recognize this car?
Yeah.
Okay, what about the other photos?
Yes, please, but you have to understand, I did not kill anyone.
Okay, look, Mr. Genesis, please stay calm. Puan DPP, are all these pictures taken on the day of the incident?
Yes, they all taken on the day of the incident.
Okay. For now, I think everything looks okay. So, alright, Puan DPP, we agree with all the evidences that you have shown us and we have no objection to them. However, we do have objections as to the truth and the contents of some documents, I believe.
Okay, just inform me if later you confirm. So, alright. Next, we will proceed to the nature of the case for the prosecution and the defense. In order for the prosecution to prove the act of murder by the accused, the burden of proof must be beyond reasonable doubt. Your client has been charged with murder under Section 302 of the Penal Code. Under this section, the prosecution has to prove that the element of actus reus and the mens rea has been fulfilled. The accused in this case may be sentenced to death penalty if found guilty. Defense counsel, do you intend to bring any defense for your client?
Yes, Puan DPP, since we disagree that my client had fulfilled the elements of mens rea, thus, I think our intention is to bring the defense of provocation and also mistake.
Okay, take note of that. Now, the prosecution would like to discuss if your client would like to enter into a plea bargaining application. So before we continue, I will read the charge against Mr. Genesis once again, okay? that you, on 26th of April 2025, at approximately 4:30 a.m. at Jalan Stephen Yong, 93250 in the district of Kuching, in the state of Sarawak, had committed the offence of murder by causing the death of one, the Muhammad Zaki bin Idris, National Registration Identification Card number 9107-6-12-2163 by shooting the victim who was inside a white car of Perdua Myvi type bearing registration number QAD3344X. It's causing his death, then thereby you have committed an offence under Section 300 of Penal Code, which is punishable under Section 302 of the same Act. So the punishable is, if found guilty, the accused shall be punished with that or imprisonment for a term of not less than 30 years and not more than 40 years, and if not sentenced to death, shall also be punished with whipping of not less than 12 strokes. Do you understand the charge against you, Mr. Genesis?
Yeah, I understand that.
Okay, that's good. Are you interested in entering into a plea bargaining application?
Puan DPP, as for this matter, our client is willing to plead guilty if the prosecution amends the charge to culpable homicide not amounting to murder under Section 304 of the capital A of the Penal Code, which states, if I may quote in verbatim, whoever causes death of any person by doing any rash or negligent act not amounting to culpable homicide shall be punished with imprisonment for a term which may extend to 2 years only, or with fine, or with both. So my client has agreed to plead guilty only if the charge is amended to Section 304 capital A of the Penal Code, as I mentioned earlier.
But this is a very serious case. So your client here, he is charged with Section 302, which may lead to him being sentenced to death penalty. And I think for you to change it, for you to want to change it to 304 capital A, I think it's very hard for the prosecution because the difference is just too big. The difference in the sentences, I mean.
Yes, and your client shoot the victim in the head, where it's very deadly. Due to this, it is difficult to amend the charge to Section 304 capital A of the Penal Code. However, the prosecution can consider the charge from Section 302 of the Penal Code to Section 304 para B of the Penal Code, which reads, whoever commit culpable homicide amounting to murder shall be punished with imprisonment for a term may extend to 10 years, or fine, or with both, if the act is done with the knowledge that it is likely to cause death, but without any intention to cause death, or to cause such bodily injury as is likely to cause death.
So Mr. Genesis, after hearing my point of view here, do you agree to plead guilty? Because if you do, you will save a lot of our time and also your time. So I hope you can think about this.
Puan, sorry. Please let me inform my client properly before we make the decision.
Okay.
So here, Mr. Genesis, what Puan DPP has mentioned is that if you agree to plead guilty, the prosecution may reduce the charge to Section 304 para B of the Penal Code, and you may be sentenced to only a maximum of 10 years imprisonment.
10 years? You want me to rot in the jail for 10 years? Really? I don't deserve this. I only doing my job. That's all.
Mr. Genesis, I hope you can remain calm.
I will, but please, both of you, help me. I don't want to be in prison for 10 years. I have a whole of life ahead of me. But yeah, I think 10 years is better than hang to death, right? Or worse, spend my entire life in the prison. So, but honestly, both sounds so bad, but I feel like 10 years is maybe better than to be hanged to death, I think.
Are you sure, Mr. Genesis? I mean, we could provide you with more information if you need to know more about this before you consider to accept this again.
So the 10 years is the maximum, right?
Yes.
So I may be sentenced with less than that.
Yes, basically here, Mr. Genesis, it depends on the judge. The prosecution can change the charge, but they still cannot make the decision as the exact sentence for you. So there is a judge to decide, but we as your counsel will help you.
I think it's okay for me.
Okay, Puan, as of now, my client stick to his decisions that he will plead guilty.
Okay, Puan Dina, please put on record that the accused has agreed to plead guilty in exchange for the charge to be amended to Section 304 Para B of Penal Code instead of Section 302 of the same Act.
Okay, Puan.
Alright, so this concludes our conference. Before we end our discussion, I would like to clarify some matter that pertaining to this case. So as we have mutually agreed on the vital issue later on, the prosecution will set up a date to proceed with the case management.
Understood, Puan. We will have another discussion with our client to him. So if we find anything to discuss again with you, we will get back to you surely.
Okay, sure. So, I just wanted to reiterate this. We have recorded the agreed evidence to be tendered before the court, namely, number one, the charge sheet that contains the charge against the accused. And then, you want to write that down?
Yes.
Okay, and the second one is the autopsy report recorded by Dr. Alisa Astor, the pathologist from Hospital Umum Kuching, Sarawak, dated 31st of October 2025, and the last one is the prosecution and defense list of witnesses. So all of the evidence that I just mentioned just now are regarded as the agreed upon evidence. Agreed? Okay. Please review this record, and if you have no problem with it, you may sign this pre-trial agreement here.
Do you mind if we take
Yes,
Yeah, sure.
Let me check first. Is this correct?
Which one?
This one? Okay.
The police report, is it? Send.
Okay.
Mr. Genesis, I hope you can sign this agreement
Where is sign?
here.
Alright, okay. So this is all for today. Thank you for attending this pre-trial conference.
Right, Puan. Thank you to the prosecution for attending the today's session.
Yeah, I am still Genesis very chill. I think I'm okay. But I think after some time of consideration, after spend a lot of time thinking, I think I'm not guilty. Why should I plead guilty for anything that I don't do? So I think I want to retract the plea. Can it be done?
Alright. Miss Najib, actually, we understand here what are you trying, what do you mean here, but I will try to inform the DPP first and later get back to you.
Yeah, sure, please help me.
Hello. Good morning, Puan Izian.
Yes.
I am Tengku Anis. We met before during the pre-trial conference on 12th November, I believe, in the case of Mr. Genesis Nicho. After further discussion with my client, he actually has decided to retract his statement, especially for the plea bargaining that you offered to us before, because he believed, and we want to support our client, that he is innocent, and anything happen, we will face it in the face of court.
Are you sure? Is the client aware that the punishment prescribed for Section 302 is worse than Section 304 para B, and is he willing to take that risk?
Yes, I think we have discussed this thoroughly, and my client is sure, and he wanted to prove that he is innocent in the right way.
Alright, if I say so. So we will proceed with the case in the trial. So thank you for informing, and I'll take note of that.
Alright, thank you. I'll see you later.